Now, I may call upon, it's my pleasure to call upon our next speaker, Mr. Balwant Rawat, who will be speaking on the issue of whether investors get the right incentive. A brief introduction about Mr. Rawat. He is the IP and innovation management leader at Mercedes-Benz R&D India. And before that, he was the head of the IP Center of Excellence team at Eaton India and senior management manager of the IP operations team at Evalueserve. He specializes in high quality IP portfolios and fostering entrepreneurship and innovation culture, as well as the alignment of IP strategy with technology and business strategies. He has had over 20 years of experience in the IP and innovation management sector in fields including automotive, IT, telecommunications, electrical, and engineering verticals as well. He was recently recognized as one of the world's leading IP strategists by IAM Media, as well as his team, MBRDI, has been recognized by both NASSCOM and CII as the innovation leader in their particular industry. Mr. Balwant has already filed 2 patent applications as an inventor and has developed several innovative IP services along with authoring several research papers and book chapters. He is a registered patent agent with the Indian Patent Office and has received his BTech from IIT BHU and an executive MBA from IIM Indore. Mr. Rawat is a prolific speaker and has presented his research on various academic and professional fora. I think that concludes my introduction for Mr. Rawat today. Over to Mr. Rawat to talk about on the issue of whether inventors get the right incentive in the IP regime of today. Mr. Rawat, over to you, sir.
Thank you, Achman. Hope you can hear me.
Yes, sir, you're audible.
Okay, so I'm just sharing my screen. Let me know when you are able to see that.
Your slides are visible, sir.
Okay, thank you. So very good morning to all, and thank you for your interest in this topic and inviting me. So before I begin, I just want to clarify that this is not my company's presentation. So all the views expressed are my own in my personal capacity, and those do not reflect the opinion of my organization. So this topic is very near and dear to my heart because having worked as an IP professional for over 20 years, I have been closely working with inventors, both from a outside service providers firm and then last 10 years in the in-house role. So I have seen that the way you treat the inventors depends on or contributes to the quality of IP and the value of IP that you get from them. So in the past, or if you have been following the developments, so a lot of developments have happened in the Indian IP field. So patent filings have been increasing gradually, and there are a lot of incentives which are given to the organizations like startups, SMEs, universities, through filing fees and all that. So my topic is also related to incentives, but incentives not to the organizations directly, but to the inventors. So what motivates the inventors to file, write IP, and contribute? Because ultimately it's the human being who are inventing, not the machine or not the organizations. It's the people who are you're treating. So my research, my observations through my experience is based on this human element, which I hope you can look at it. So comes from the different background that I had overall in the field of management, in the field of IP, in the field of innovation that I am now driving at my organization. So then moving forward, uh, I would want to also talk about the incentives that we have also given in our organization and how these incentives can be scaled up at the national level. So let's begin with one observation which I just collected yesterday from WIPO. So I looked at in the year 2020, what has been the trend of filing, patent filing by resident entities. So resident entities would mean that the companies or the organizations that are situated in that country. So if you look at the India, there were 23,000 patent applications which were filed by domestic companies, or even if MNCs were there, their Indian arm were filing it in India. So the count is around 23,000. And if you compare it with the top 10, now the good news is that in that count, we are already in the top 10. Our rank is 8th in terms of numbers. However, if you look at the share of the filings based on the numbers, we just represent 1% of the top 10 countries, which is a shame considering that we have over 1.4 billion population. We are producing the world's largest number of engineers and scientists every year, and even contributing to 25% of world's engineers globally. And China, if you see the comparison, which is also a neighbor, and also with a similar population, similar things and all that, it has really come to its potential. So if China can do it, what stops us? So now, since I talked about China, so let me also give a quick comparison, which I did. If you follow the trend, and in the early 1990s, China and India were not very much different. In fact, in some areas, China was worse than India. Look at this statistics from the World Bank, which talks about the poverty rate, which were over 70% in China, and at that time it was like 55% from India. So India has made improvements, but look at China, how they have really handled it, and now they are coming to literally close and really leaving everybody behind. So of course it boils down to the economic development, which of course is IP is one part of it. Look at the patent filing comparison that we have. So here I've compared Indian patent filings. So India, I don't know whether you are able to see that in the list. So let me look at the pointer options, laser pointer. Okay. So India is somewhere here, which has been very much incremental growth over the last 20-25 years. And these are the other developing or developed nations. And look at this graph, which has come from China. Now, if you see the trend of this, acceleration really happened at a fast pace somewhere around 2008. And I looked at what could be the possible reasons, and I found that amongst different initiatives that were launched by China, there was introduction of inventor remuneration law in India to incentivize the inventors, and which basically said that, the moment the patent is granted in China, the organizations need to pay certain award, no less than 3,000 yuan. And if it is commercialized, then they should share that revenue or the profits, 2% profit from the exploitation of patents. Or if it is licensed, then 10% of the license fees with the inventors, which is a pretty bold move. And China was not the first country to do that. I will talk about it a little moment. But the related thing, what has happened from 2008 till last year, I also compared how China fared in the innovation. So the global innovation index rating that you would have seen. So I compared what was the rating given to China in 2008 compared to that in India, and 2021 where we are. So if you look at even in 2008, we were not very far behind. We were ranked 41 and China was ranked 37. But now look at 2021 ranking, which is 46 rank we have, and China has 12. That's a huge, huge margin or the gap that we have compared to China. So this is just a comparison, and I'm not saying that the inventor remuneration law is the only one. There are different factors, but this is also one of the factors or one of the best practice that we can look about where I would want to focus on. Okay, so moving to next steps, there has been some talks. We all know about national IPR policy, which was launched in 2016. So there are some mentions about incentivization of all the users, including inventors. It's not so direct, but objective 2 of national IPR policy clearly says that in order to stimulate the generation of IPR, there needs to be incentives built in the system to encourage filing by such targeted users. And we have seen that reduction of filing fees is one of them. But it also talks about that it should be through entire value chain from IPR generation to filing to commercialization. It also talks about in section 1.4.4 that there has to be some prizes or some awards to generate IP in specific sectors. And it also talks about not only organizations but also the researchers in the publicly funded academic and R&D institutions, so that there are some uniform guidelines about division of royalties between the organizations and the individual researchers and innovators. Okay, so that's also interesting thing that has been mentioned. And talking about university students, it also talks about that we need to encourage and incentivize IP generation and utilizations amongst students at all levels. Awareness programs, definitely, and educational material that Professor Anandya talked about in his previous session. So pretty good. Now we are just mentioning about what can we do further. So coming to the incentivization of inventors. So I gave an example of China, but are there other countries? And when I did my own research in my some free time, I found yes, there are inventors right to remuneration. It exists. I could find more than 14 European countries and more than 7 Asian countries, but there could be even more, which expressly mention this clause that inventor needs to be remunerated in case of service inventions. So let me clarify, what do we mean by service inventions? It's for the IP which is filed by the organizations. It could be large entities, small entities, SMEs, MNCs, even universities, they are filing as a legal entity. But IP is created by inventors and it is then assigned to the respective organizations. So ultimately, it is the owner of IP, which is the organizations, the assignee, who takes control of what to do with IP, and all the rights belong to the owner. Inventors mostly have the moral rights, but nothing else. So we can see in this chart that Europe, Germany, Denmark, Finland, Norway, Poland, UK, Netherlands, France, Italy, Austria, Portugal, Spain, Hungary, Russia, they all have the clauses which I was able to locate. And I will give a few examples in my later slides. And why go far? Let's look at our own continent, Asia, where so many countries like Japan, China, Korea, Malaysia, Vietnam, Thailand, Sri Lanka, all our neighbors have such kind of laws. And Japan has this law from 1959, more than 60, 70 years. Okay, and we all know as a nation, as in terms of IP, how well matured that IP, the nation, Japan is. Okay, so we can learn a lot. So let's also briefly compare that when we talk about rewards and remunerations as per these laws, at what stage of patent life cycle these are given. So it could be at the filing, it could be at the grant, or if the company is using licensing or selling. So basically the monetization level. So China, I talked about. So at the time of grant, they say that there has to be 3,000 yuan, which could be 30 to 40,000 rupees in Indian terms. And when it is monetized, then there has to be some 2% profits. And so it's very much direct how much it has to be done, and the organization has to follow this. Germany is also the one country where it has really evolved, and there are a lot of details, mathematical calculations on how this right amount is derived. So since our company is also, I'm dealing with inventors in all these countries in China, Germany, Japan. So I can get some practical experience on that. So for Germany, they have a formula that uh, was first to calculate the invention value, and they use the licensing analogy or the cost savings that the company is getting from that invention. So only if that invention is valuable, it is of use to the company, and it is monetized, then only the compensation clause will come in at a later stage. And then based on your contribution level and how many inventors you have in that, so accordingly you will get your share. Russia also has it, though it's not mandatory, but some guidelines are also mentioned, which is equivalent to at the filing time 30% of the average monthly salary of the inventor. So it can vary depending upon at what level of salary that inventor is drawing, and at the time of usage also an average monthly salary of that each year of use, or 10% of licensing revenue. In Japan and Korea, so they do not prescribe any limit or let's say a percentage, but they focus more on the process which is derived, uh, so that the process should be reasonable, which is agreeable to the inventors and the company. So as long as the process is reasonable, the amount is supposed to be or assumed to be reasonable as well. So they only provide guidelines, and which I will talk about what the kind of guidelines are there. In comparison, India does not have any such laws. It is silent on this topic, and that's why any such remuneration or rewards are governed by the contract law. So every company which is operating in India, that's free to do it in their own way based on the contract that they signed. And all the IP that is generally generated as per the employment clause, also there will be agreement which will say that all the IP belongs to the employer, and inventors don't have much say generally. But I have seen that many companies, especially the big companies in India, they have this best practice that at the time of filing or at the grant, they will give some amount of cash rewards, could be up to $1,000 per invention. But typically those are given at the filing or the grant stage, not at the usage or licensing or selling at the later stage or revenue based thing. So we did a survey also recently, I will talk about in a later moment. So let's look at some of the clauses which we can understand from a legal perspective, how they are legally binding the organizations to follow some common provisions. So in Japan, this Act of 1959, and which was of course amended in 2005 and 2016 to provide even more better clarity. So they clearly say that if the employer is taking over the inventions from the inventors, in return, the inventors have the right to receive reasonable money or any other economic benefit. So it need not be the cash, but it could be, um, let's say, paid holidays, or it could be anything which has some economic benefit to the inventor. So this is clearly stated. And the second clause, you can see clause fifth. So this is about the process that needs to be set by the employer, which would mean that while setting up this company policy, they need to have this negotiation with the employee. They need to communicate the criteria, how the how the remuneration would be calculated, uh, and it is open, it's visible to all the employees. And at some stage while setting up this policy, the opinions of employees have been taken to consider that. So once that part is processed one time, then it is supposed to be reasonable within the company. And if they don't do that, then definitely there could be cases where, and it has happened in the past that there has been some lawsuits also. And some general guidance is given that based on the employer can see how much profit that invention is generating and how much contribution has come from that inventor to generate that profit. All that different circumstances based on which one can come up with some guidance. But then it is better that it is done one time, and that's why if you see the trend from 1959 till date, I was reading, uh, the law was always there, but not many companies have actually adopted it. But after the 2005 amendment, when it was mandatory to avoid the lawsuits, uh, to make it to disclose it, then a lot of companies have really adopted this technique, and now it is very much consistent. So let's look at the research, because this law has been in place since 1959, and of course after 2005 there has a lot been development. There were several research studies done uh, in Japan, Germany, and the US. I have also given the source in the bottom, and of course it will be visible. So the researchers have found out that, and of course based on different surveys that they had done with all the Japanese, thousands of Japanese companies, the R&D data, the patent filings. So there are three key findings which I could gather from multiple research papers. So first part is they observed a clear correlation that if you have a revenue-based compensation revenue-based compensation plan, I'm saying that money given not at the time of filing or grant, but the filing, but rather the money which is linked to the profit that the company is making at the time of monetization stage. So at that time, if you are if you are sharing, then this policy or this process is leading to more valuable patents. So automatically the quality of IP that is filed, and you can also see from a number of forward cited patents as well, a number of commercialized patents as well, it increases. So it may not lead to unnecessarily more patents, which will add to the noise burdening the system, but really good quality IP, valuable IP that comes by having this kind of provisions. And what is more important, this trend was very much evident in the smaller firms than a larger firm. For large firms, generally, the process is mature. They have their own process and all that. For larger firms, it's not a big problem. But I'm talking about the SMEs and the smaller firms, and it is very much important in India because we have so many of them. So if you link it, definitely the quality and the value of IP will improve. That's a clear observations, consistent. Second, what they have also seen that monetary incentives that you give based on the performance of the patent, it also motivates the employees, inventors to put in more effort in improving the quality and to make sure that the commercialization happens. I have also seen in my career that it is easy to submit a patent applications, but much more harder to convert that patent to innovation or to launch that product in the market. So it's a lot of hard work that goes in for commercialization, and we need inputs at a later stage also. But this incentive, which can be linked to the performance-based incentives, as many corporations have that. So if the patent is performing, you also gets rewarded. And third finding was that having a formal law like what Japan has, it leads to adoption of this practice amongst all the or most of the companies that are situated there, and which ultimately helps in nation overall IP generation and value. So this has happened in Japan. So this is one good learning which I could draw out from this research study. So moving on, I think German inventor law is also fairly detailed. You can see that this section 9 and 12 and 42, it talks about when and how, based on the usage, this amount should be calculated, and and uh, and an option can be given to the inventors. What happens in many of the organizations that based on the fair share, they will give it either as a lump sum or based on year on year revenue, then a certain percentage will be given to them. So it may be compared to a stock option that you will get some kind of ownership and accountability based on the quality of IP. And German inventor law is not just talking about corporations. It has specifically mentioned for a university, there has to be a provision. Then if the employer, which could be the university, then for any such exploitation, the inventors get a 30% of the revenues up to that extent based on the exploitation of invention. So that's also very much motivating. So similarly for China, so China is also fairly simple where they have mentioned the limits, the minimum limit that needs to be given at the grant stage. And of course, so they classify as reward and versus remuneration. So reward is when patent gets granted, and remuneration when it gets commercialized. So it could be a lump sum payment, which is 2% of the overall profit, and 10% in case of it is licensed out. So talking about our own Indian context. So last year, so I worked with different organizations, so specifically an IPO and KPMG. And KPMG helped in doing a exhaustive survey where they talked to 150 respondents from 30 diverse organizations based out of India. It could be Indian and global MNCs, SMEs, academia, research organizations, different things, just as a sample size. And then they asked certain basic questions. Do they have such remuneration policy in their company or organization? And how do they give these awards? What kind of awards these are? So there were some interesting results which I would want to share from that report. That so first they asked a direct question: what do they think whether such an inventor reward policy do they motivate inventors? And 95% of them said yes. They definitely encourage it. Second question was also related to the laws that I talked about the inventor remuneration law, especially the post monetization law. I'm talking about not at the time of just the filing or the grant, whether they would recommend such a law should be given or should be implemented in India, whether it will help India as well. So 57% said strongly agree, and 34% said agreed, and 9% were neutral. So you can see that over 91% of the people were in agreement, and 9% was just neutral, but there were no negative opinion on that. So now we know that there has been a general agreement that there should be there. Right now there is no law as such. But let's look at what are the different kind of incentives. And that's where I'm coming to the rewards versus recognitions, or balancing the rewards with recognition. So if you want to give incentives, it may not be just monetary incentive. It could be monetary as well as non-monetary, and both are important. So first part is, of course, the monetary incentives, which will cater to the extrinsic motivation of the inventors, which will include the cash awards, economic benefits, promotion possibilities, promotion or salary increases, all that, if those are there. So uh, in the survey report, so 36% of the respondents said that they have this cash rewards. 19% said they have this performance appraisal. And I'm talking about those organizations which have this policy. And I just forgot to mention that 50% of the respondents, they had certain rewards at their place, so 50% didn't have. And those 50% have these kind of policies. It could be cash awards or even certificates or things. So I talked about the extensive motivation part, their monetary awards, but the other part could be intrinsic motivation or recognition part. And both are important. If you have read about the management philosophy or Maslow's hierarchy of needs, so that's where all this money, pay, that will lead to the safety, physiological, all that needs within the organization. Whereas the recognition is also important. So both should be balanced. And in our own organization, just to give an example, we have both kinds of initiatives or incentives given to the inventors, which has actually led to uh, increase of patent applications coming from our India center, uh, 5 times growth in the last 10 years. And not just in the numbers, but also in the quality as well. And now, outside of Germany, we are the largest uh, patent filers in the world from our organization, this India center. So we are filing more than the patents that are coming out of our company in China, in US, in Japan. So outside of Germany, we are the largest. So this had been only possible because of these different initiatives that we had taken. Talking about the recognition part, there is one more gap which I feel there in India, and definitely the stakeholders here, especially the patent office or industry bodies, can take it forward, which is to recognize the inventors at the national level. And I could find four examples specifically. So first part is the European Inventor Award. So it's an annual award given by the European Patent Office. So all the patents that gets filed in the Europe, if those inventors have really made a difference, and this is all these awards are given to the inventors, not the organizations. So that's why they are unique. Uh, so they recognize all the companies, inventors who are from Europe or inventors from the companies which are doing business in the Europe who has made exceptional contribution to the social development, technological progress, and economic growth. So all these top inventors are awarded in Europe. Similarly, US also has this National Inventors Hall of Fame. So all the US patent inventors who have made advances in the science and the useful arts. Germany has its own award. They call like a German Future Prize, which honors this exceptional achievements in technology, engineering, and life sciences that have resulted in the viable products. So it's mostly IP which has really given value to the society. And of course, there is a WIPO medal for the inventors, which is a policy or guidelines for all the member countries. It was launched in 1979 that different countries can give this inventor medals to the top inventors who have really contributed to nation's wealth and development. So there is a lot of scope. I have not seen, but that is what I would also strongly recommend. So for European Inventor Awards, so it has actually evolved just as a case study. So they give inventors from industry, from research, from non-EP countries, from SMEs, and of course inventors who have like a lifetime achievement. And very recently, they have come up with a Young Inventors Prize for inventors which are aged less than 30. So if their inventions and patents have made a difference to the society, they get recognized at the national level, which is a big motivation for the inventors. And why can't we also do that? So coming to my last slide as a summary. I would want to propose four recommendations, and of course urge all the IP and innovation community if they can help and contribute through further research and discussions, so that there is a strong incentive systems mechanism system built in our institutions for inventors that will promote quantity, quality, and value of patent applications in India. And not just like a policies or all that, we should actually promote it as that receiving this kind of share or benefit it should be a right. And we need a strong motivation from the inventor community here. We need a strong voice to do that. If you remember our own freedom moment, right? All that was like the right to Swaraj. So all that, the moment you recognize that it is already yours, you have contributed towards it, you just need to get it. So if we are able to get this feeling within all our inventors, naturally there will be a push from or a pull from all the inventors to contribute actively to file more IP, file really useful, valuable IP, which will help both the companies that they are working in as well as the inventors. And overall, as a nation, uh, India could be seen as not as a back office, but as a innovative nation. And ultimately, that will also help its Make in India movement and attract all the uh, investment that is needed to grow our economy. So how it has to be done, that can be done, further research can be done. We can learn from different countries which have actually adopted these laws. As long as we can have a reasonable process, we can think about a system which is simple and easy to implement and also which is Indianized. So that could be on the remuneration side. And of course, on the recognition side, my recommendation would be to have a national awards for the Indian inventors, which is prestigious and that can actually help in making our inventors the heroes. And India should be known for all the scientists, all the top inventors. So this they can be really brought to limelight. So that will be my take on it. So thank you so much for listening, and I'm open to my questions. Any questions right now?
Thank you so much for sharing your insights, sir. I certainly think that with incorporating these recommendations, the country as a whole may shift from a back office orientation to more of a creative lead. So, to that effect, we also have several questions in the chat. If you don't mind answering them, is it fine if I read them out to you?
Definitely. So I would love to answer these questions, and if there are other members in the panel, please feel free to put your thoughts.
Okay. So Mary asks, what is your take on secrecy directions imposed as per the Patent Act in India? She says that the inventors are discouraged from venturing into that domain as once imposed will prolong the duration to reap the rewards. So, what is your take on the secrecy directions under the Patent Act, sir?
So it's my opinion that secrecy direction does not prevent you to file a patent. Just that it will be secret, and ultimately the government would be the primary user as per the laws, which could be important for the nation's safety. But definitely, even if you're filing patents in these areas, it is of some use to the nation. And if not everybody, but at least government could be really helping in that part. I don't see as a deterrent, but yes, if it is quite an important area, you can certainly file IP in that direction, just that owners would be different.
Understood, sir. So there's also this question by Mayur where he asks, idea generation to patent grant timeline is lengthy. Does this impact the psychology of inventors? Because by the time invention is about to receive grant, the inventor no longer remains with the employer. So do you see this as a challenge as well?
I certainly see as a challenge, and this challenge is not unique to India. All major countries, they have a time gap, though the time gap is decreasing. And in my view, the awards, if you want to talk about, it also needs to be instant. So that's where a balance can be put in, that if award is given in different stages, at the time of filing, certainly that's an instant award. Second stage is at the time of grant, that you give certain amount, and then third stage is at the commercialization stage. So if the rewards or the recognitions are given at due stages, we can do a little better.
Absolutely. So there's also this question on corporate IP base, where someone asks that often in MNC in-house offices, the IP related work rests with headquarters in US and Europe, whereas Asian offices are seen as back offices, as you said before. Do you think this status quo can be shifted to increase the Indian corporate IP base? I think you have already put some recommendations in, but probably you can, shed more light on what steps could possibly be taken to that effect.
Hmm. So I won't say it's a bad thing. Ultimately, even on our companies, or many companies which are based out of India, so the owner would be the central entity, and it is not just for India itself, because talking about uh, my own company, so all the IP that gets generated from different regions, let's say China and all that regions, definitely those will be ultimately assigned to the headquarters, and in return, those are given as a license. So companies take this decision generally to make it easier to handle the different complexities related to licensing and all that side. So it's a company's decision to do that. Uh, and ultimately, the inventors in those countries also get recognized so far. So I don't see it as a challenge. But yes, if there is a more business that comes out of that country, or more participation, we would want to have more and more inventors contributing that IP from that region. And it doesn't matter whether the owner of that IP, in case of MNC organization, whether the ownership is with any other country, or ownership is based out of uh, company which are situated in India. I don't see that as a much challenge. Right now, let's focus on generating IP first, generating more and high quality IP. And ultimately, all that ecosystem will help all the domestic companies which are based out of India.
So, sir, am I right in saying that IP laws that are existing right now, while you don't have a problem with the ideas, the ownership of the ideas going outside, you think that the focus should be rather on incentivizing innovation in the first place? Am I right in making that statement?
So incentivizing the inventors so that they are motivated to create more IP at that stage.
Okay, got it, sir. Got it. Thank you. So, Pankaj Sahai asks, for filing, do you use FFP or file in India first?
Uh, More than 90% we'd file it in India first.
So, can you probably, because I'm unaware of what the FFP means, I think several of our attendees would also not know what this means.
Yes,
So, if you can possibly shed some light on that.
definitely. So for the global MNCs which are operating in India, or any other company which wants to file a patent first in a foreign country based on where the market is, they have a choice to file first in India, and then once the filing is done in India, then they, as a priority, they can file it in a different country, let's say the US, or they can directly file the application outside of India. For that reason, they need to take a FFL, or a foreign filing permission from, or foreign filing license from Indian Patent Office. So that's the difference. Uh, Typically, we prefer filing it in India first, because it is quicker, and it gives you, it can give actually give you the head start of at least a few weeks in priority date.
Thank you so much for that explanation, sir. So there's also this question with regards to IP ownership, where Kiran Kumar asks that do you think that the approach of the employer owning all the IP over the inventor who is working for that particular employer is the best way to go forward? Or would you rather think that inventors may be incentivized more if they were made the actual owners of the IP that they're producing while working for someone else?
So at the first instance, in many countries, inventors are the owner first, but we have to also look at the difference that the contribution of the organization to convert an idea or inventions. So you will see that first of all, it takes a lot of money to file and get it granted, which inventors may not have all the financial resources to file IP or to get a IP granted. Then to convert that IP to the innovation or the launch products, inventor itself cannot do. So that's where the value that the organization is providing to have the right environment, the resources, so that that idea can get uh, monetized or commercialized. So that's where, because there is also a big risk, because not all patents will get commercialized. It's just 5 to 10%, and rest all may just stay in paper. So who is willing to take that risk? It's generally the organization which can take the risk. Inventors may not be able to do that. So that's where world over, the organizations then they become the owner. Uh, Basically, then based on that, they have hired the employees to create those kind of inventions. So it has resulted not in isolation, but in certain countries, I have also seen that there is a concept of free IP. So if the employees have not come up with an IP or come up with an IP without using uh, employer resources on their own, then they will be owner of that IP. So this is like a free IP. In many countries, they recognize that. So they have that freedom. India does not have such clarity in that here, that a free IP or the service IP. Generally, it is spawned by the contract law here.
Got it, sir. Uh, I certainly understand that. Do you think that this free IP concept should then come to India as well? Because understanding that employment contracts usually provide for that all the IP that is produced within that term of employment will belong with the employer and not. There's no distinction between the IP created using the company's resources as opposed to something that is uh, created on one's own enterprise.
So certainly we can look at that part because this practice is there in many countries, and it's a research topic whether it should be done, not done, or how it can be established. But yes, why not? Let's do a research and find out and get a voice of introducing this provision also. That will certainly help the inventors.
Got it. So, for anyone who's tuned in to find out or discover possible new research topics, this one's for you. And there's another question which might require more research. And Sakshi Bhatnagar asks you, sir, that what is the present trend for IP ownership for AI, artificial intelligence generated works, especially computer generated works?
Yeah, so I heard many news in many jurisdictions. This is one of hot topic. Uh, I think most of the countries they do not recognize machine as the owner. Although I heard that I think one country uh, did recognize. Uh, I'm forgetting which country, whether it's South Africa or UAE. Any one country talked about it, but world over there is a almost a consensus that it's the human beings who will be the inventors, and machine will not be given that ownership or the inventorship for IP.
I think it was South Africa because they
Yes,
don't have a substantive examination procedure.
yes.
It was about that the Europeans refused it first, and it was not granted anyway. South Africa doesn't have a substantive examination, they allowed it.
Yeah.
Got it, sir. So do you also think that with the burgeoning of blockchain technology and several other applications such as cryptocurrency and NFTs, we can also see a burgeoning in the call for incentivizing inventors and designers, so to say, more through these technologies, or using these technologies, building a platform where the incentives are directly uh, associated or directly delivered to that particular IP creator or IP generator?
Why not? I am also hearing news, or there are instances of using blockchain in the patent offices, because it's a wonderful technology to as a ledger, a digital ledger, to so that you cannot fake it, and it could be a good way to track the development of as the product is going through the commercialization or monetization stage, to record every instance, and this could potentially be used.
Got it, sir. That answers my questions. If there are any other questions for Mr. Rawat, please feel free to put them in the chat. So till then, we have a comment by Mr. Shashank, who says, Mr. Rawat, excellent. Obviously, as you said, no legal right of inventors in India, but in public sector scientific research in India, IPR guidelines for benefit sharing through IP commercialization do exist in major scientific organizations and are slowly bringing a change. In 2007 to 8, DBT-GOI piloted a public funded IP bill equivalent to the Bayh-Dole Act of USA. Sadly, it could not go much further. Would you like to comment on this as well, sir?
Definitely, there could have been an objection at that point of time, and due to priorities of government at that different point of time, it was dropped. I don't know the exact reasons from that, but I think if you look at it a holistic way, uh, for the national interest, the inventor community, for the benefit of that, and that will include all the inventors, whether they are coming from research organizations, universities, or even corporate setups. Uh, we can bring in some harmonization now, and we should look at the global best practices in that regard. So it should be done differently, and that's where I also call about from the student community here, if they can do further research to how these kind of laws can be implemented within in India. If you just directly take the provisions from the US, it's the Bayh-Dole Act, and just do it, implement it in India, it may not work, or it may uh, lead to a lot of objections. But if we understand where these objections were coming from and do it a little bit more creative to implement within Indian context, I think we can make much better progress now.
Certainly, sir. I think the common thread through all the talks that we've had today and the previous IP seminars that I have attended is that simply transplanting laws from foreign jurisdictions will not really serve the Indian IP market and the Indian IP sector well. But there has to be some changes made to ensure that the laws that are brought in suit the Indian market requirements. So, can you also probably talk a little bit more on creating standards for the IP sector, SEP, and the other incentives that are related to it?
Yes. So creating the standards and SEPs, for that you will see before the standards are derived, the inventive activity uh, begins much earlier. And as a standard setting bodies, then different partners will give their own solutions, which can be then discussed and agreed upon. And whoever partners solution is proposed, so the patents related to that, those are pulled in, and they will actually benefit from that. Now there is a opportunity because the technology is changing fast, And in the area of IT, digital technologies, communication technologies, it is our Indian engineers who are active in that domain. So if some efforts are done from their side, so that they are proactive in creating right patterns for the solutions of tomorrow, and that's where filing of high quality IP would be the first step towards that. So that then only you can talk about contributing these patents to the patent pool and creating that kind of standards. So we have the talent, and if we just utilize that, then whichever companies are participating, whether it is the MNCs which have Indian inventors, I have seen so many of my friends who are uh, the inventors for such companies in India, or it could be the domestic companies which can actually participate more actively now in those standard bodies to create those patents and also submit those patents. And definitely the big incentive would be that if it becomes a standard, the company has a steady set of revenue that comes from those as a licensing revenue. And of course, it's a big incentive for the inventors as well.
Fully got it, sir. Got it. Thank you so much for that. There's also another question on AI and ownership of IP. So Pradanya Chavan asks, I'm sorry if I'm mispronouncing your name, that can we expect the Indian courts to take a view similar to the view of the Australian courts in Thaler versus Commissioner of Patents relating to recognizing inventorship for AI? Or would you think that the Indian courts are more oriented towards a more uh, individual or a person oriented ownership when it comes to AI and the IP that they develop?
Well, I'm not an expert in the AI space. So for the topic, I would prefer more on incentivizing the inventors. And if the ownership is with the human beings rather than on the machines, so the inventors, definitely that would be a better approach in my view.
Thank you for that, sir. Sir, considering that we're running out of time for this session, would you like to share any concluding thoughts with regards to what you finally see as the way to go forward in respect of giving the right incentives to investors in the Indian legal framework today?
Yes, there's only one key message is somehow through this community we can, um, if you want to increase the IP awareness, if you want to really improve the quality, the human beings, the inventors are the key. So whatever research or support you can provide to bring that law, if we are able to convert that, I think that will be a big motivation or the driving force, and it could be a game changer in my opinion. So requesting all the stakeholders to commit to the cause and in whatever way you can contribute. If you have further ideas, you can uh, reach out to me. I have given my email address in my presentation, which would be of course shared. Yes,
Thank you, sir. Sir, do you mind taking another question? Because we just got a fresh question in the chat.
sure.
Okay. So, sir, Ashish asks that US has an IP task force to handle IP crime. Can you possibly tell us more on that? And he also asks that in India, lots of products are sold in the local markets, which infringe products, but it's difficult to tackle them in the Indian judicial system. So I guess what he's coming onto is that the IP enforcement is not as strong as in India as it is in the other jurisdictions. So can you identify any particular problems with the enforcement mechanism that is leading to such a situation from happening, that is leading to such a situation in India, sir?
So So my personal observation is that over the years, the enforcement mechanisms uh, have actually improved. There is a lot more awareness in the judiciary now, and if there are disputes, we are, of course, not to the extent of the US or the European one, but definitely we are much more neutral. Uh, and there are a lot of cases, lawsuits, which are in favor of the patent holders now. And if there is any IP crime or the infringement and all that, it's easier to now file a lawsuit or stop through the different legal mechanism that we have in India. Though there could be them, but I have seen that it has actually improved over the last decade or so, and it will continue to improve as the quantity and the quality of IP in India becomes or improve further. So mostly, if you see the jurisdictions or the many lawsuits that has happened, is for the patents that were originally filed in other countries and then later on it were filed in India, mostly in the standard bodies and all that. But if there are more and more participation from the domestic players, automatically that awareness will improve, and accordingly the judiciary will also get uh, will also recognize and will also gear for it.
Thank you so much, sir. I think that answers all the questions that we had for you today. Thank you so much for taking out time on a Saturday morning to join us and share your insight with us today. I hope you stay back for all the other sessions that we've lined up for today and tomorrow. Thank you so much.
It's a pleasure. Thank you so much.
Thank you, sir.